So I'm going to turn it over to Brandon here. So if you'd like to please join me, give a very nice warm welcome to Brandon.
Alrighty. Thank you for coming. My name is Brandon Alexander Adams. Everyone on the phone can hear me? Yes?
You bet.
Okay.
They're muting it.
Okay. Wanted to, this particular class we're going to do today is an introduction, laying a foundation for the inner workings of commerce. For those of you who are unfamiliar, the entire global system of government and economics all operate in the system of commerce. Today we won't actually go over any specific procedures. Today is basically just foundational so that you get an idea of how things are working. Once you have an idea of how things are working, we'll actually move forward with actual procedures that we use as creditors. We will distinguish between operating as a debtor and operating as a creditor. However, I'm sure none of you need any education on operating as debtors, seeing as you're educated by the public school systems to be debtors from the time you're very young. So we won't be touching too much on debtors other than to make the distinction between how a creditor and a debtor differ in their actions within commerce. So to start off, maybe I'll go through what I call law forms and jurisdictions to give you an idea of what those are. Okay. Law forms, we can look at it like a pyramid. Each successive law form falls within the law form before it. And at the top of the pyramid, we have natural law. Natural law is that law form that makes it possible for you to be here. Your existence, creation itself, the physics of the universe, all come under natural law. Okay? Underneath natural law, the next law form would be commercial law. Commercial law is any interactions between sovereign beings. When I say sovereign, all I mean is someone who has control over their property, not someone who is in possession of property, not someone who is an owner, but someone who actually controls. Okay? Two sovereign entities have complete freedom to contract with each other in any way that they see fit. There are no oversight of their contract. If two individuals outside of any jurisdictions decide to contract between each other, that would be in the area of commercial law. The next level down I would call common law. Common law is a society or a group's agreement on how to interact with each other. For instance, you have the United States. And the United States is a society. And within this society, we have decided that there are certain guidelines under which we will conduct business with each other. And we are in agreement under those guidelines. So that's what I would call the common law. Now, within the common law, I don't mean it in the sense, if you've heard of law forms such as admiralty and commerce and statutes, I'm not talking about it in that sense. When I say common law, I'm just meaning, in general, a group of people have decided to be under these guidelines. Okay? The next level would be what I call statutes. Now, statutory law is, for example, the U.S. has 52 titles of statutes in the U.S. Code. For instance, I'm sure you've all heard of the tax code. And the tax code is Title 26 of the U.S. Code. That falls into the arena or the law form of statutory law. Underneath statutory law, is it 1, 2, 3, 4? Yeah. We have the we have the final law form, or the lowest on the pyramid, and I would call that political law. Political law, for instance, this may be a bad example, but if I play in a soccer league, I am under the laws of that soccer league in what I do. There are no statutes in the U.S. Code that say this is how you play soccer. Okay, so soccer has its own group of laws, and that would be underneath all of these, because the field I'm playing on may be in a public area where statutory law prevails, so I can't shoot someone on the soccer field, even though the laws of soccer don't exclude me from shooting someone. The statutory law governing the law that the soccer field is in does prevent me from shooting them. But the political law of soccer says I can't hit someone, I can't push them over for no reason. So that gives you that's the basic law forms that we will be discussing today. Most of us operate in statutory law. If you operate as a U.S. citizen, or as a U.S. corporation, or as an officer of a U.S. corporation, you're operating within statutory law. Now, the advantages of understanding how to be a creditor in commerce is that you will learn how to operate in the highest law form, which is commercial law. And you will learn to do that through being as a creditor, you will learn to control property. Okay? Does anyone remember the quote by Rockefeller back in the early, I believe it was the 1800s, early 1900s? It was early 1900s and the antitrust things were going on. He said something to the effect of, and I'm paraphrasing, own nothing, control everything. Has anybody ever heard that quote? Okay. Do you own your car?
No, I do.
Well, let's say your car's paid for. Do you own the car?
No.
You do own the car. Okay? You do not control the car. Can the state take the car away from you? Yes, because they control it. Okay? Now, there are two different types of title. There is equitable title, and there is legal title. Okay? Equitable title is owner, operator, debtor's title. Okay? When we say you own your car, that's what we mean. You have equitable title, meaning you can sell it and you can make money from selling it, but you do not have control over the vehicle because you did not issue the title for the vehicle. The state issued the title, and they gave you a certificate of title. Okay? That means they're holding the legal title. The legal title to the car was actually the MSO that came from the dealership when you purchased the car. The MSO got sent to DMV or the state to hold. They are holding the legal title.
What it stands for,
MSO, Manufacturer's Statement of Origin. Yeah. So that's the actual title on the vehicle. Okay?
Do they ever disclose that when they sell you the car and you just don't know where?
No. Actually, you do sign something that gives them a power of attorney to send it to the state. Okay? Your documents that you sign in closing on the vehicle, you basically give them power of attorney to take the MSO and give it to the state on your behalf. Now, if you were purchasing the car and you told them, I am taking this to a foreign jurisdiction, I am not keeping it here in the state, they'll give you the MSO if you ask for it. Okay? But again, That's a procedure, and we need to talk about being a creditor. I wouldn't suggest to anybody in here that you go and take legal title of your vehicle, because being a creditor involves a lot of responsibility. Okay? The person with legal title takes responsibility for the property. Okay? So next we'll talk about, we did law forms. Maybe I'll do jurisdiction.
There was equitable title.
Equitable title and legal title. Okay, you'll hear me a lot of when we're speaking. I'm going to give you some foundational stuff so that when I say it, you'll know what I'm talking about, because I'll use a lot of terminology. If you have any questions about the terminology I'm using, ask, and I'll clarify for you what it means. We'll have an official question and answer session as we roll up towards the end, and then we'll pass the mic around for questions. Otherwise, I'll repeat the questions best I can into the mic. Okay, you'll hear me talk about jurisdiction A and jurisdiction B. Okay. Now, these are not official titles of actual jurisdictions. So, what I'm talking about when I'm discussing jurisdiction A and jurisdiction B, jurisdiction A, I will also refer to as private. Jurisdiction B, I will refer to as public. Okay? I'll also refer to jurisdiction B as a democracy. And I will refer to jurisdiction A as a republic. Let's see, how else do I break down jurisdictions? That's good for now. So, how many of you are familiar or know the difference between a republic and a democracy? Okay, a couple people. When the United States was established in 1776, not 1789, with the Declaration of Independence, we established, through the Articles of Confederation, a republic. A republic is sovereign. It controls its property. Okay? In 1782, with the end of the Revolutionary War, the national government went to the people, or the states, I should say, and asked the states to foot the bill for the debt that had been incurred by the national government. With the creation of the national government in 1776, or the signing of the Articles of Confederation, the national government took on the debt of the Revolutionary War on behalf of the states. Okay? The states in 1782 basically said they would not pay the debt. Okay? So the national government was forced to form a constitution. Okay? Does anyone know what a constitution is? Okay. Does anyone know the definition of a constitutor? One who creates a constitution. Definition of a constitutor is basically one who passes his debts to a third party. Okay? If you read the Constitution, pay very close attention to the preamble in Article 6, you'll notice that they capitalize a lot of words that really, by the proper use of English, shouldn't be capitalized. Right there in the preamble, it says something about securing the
Blessings of liberty.
securing the blessings of liberty, and it's capital B, capital L. Okay. The Constitution itself is a security. Because the states wouldn't pay the debt, they had to create a security with sureties to basically back the debt, so that the national government could do business with other national governments. Basically, if you don't pay your debts and don't have a surety for your debts, no one's going to do business with you. Like when little Timmy, 16-year-old Timmy wants to go buy a car, is the dealership going to give Timmy, approve his credit to be on that vehicle by himself? No, he needs a surety, a cosigner. Okay? So the states signed on the Constitution as sureties, saying, yes, we will back the debt of the United States. Okay? So in 1789, with the signing and the completion of the Bill of Rights and the Constitution, you had a security instrument for which the debt of the United States was now attached to. Okay? That debt, we basically went into what's known as an international bankruptcy at that point. Since we didn't pay the debt, the national government went to the UK, the King of England, and said, will you buy this debt? The King of England said, sure, we'll back your debt, we'll pay your creditors. And in exchange, they took legal title over the national government's property. Okay, so since 1789, you've basically, in 1789, the national government lost its sovereignty. So we were a republic for 7 years, 1782 to 1789. Yeah?
But does that only count for Washington, D.C. and federally owned territories as opposed to the sovereign states?
At the time it did. We'll get into the sovereign states dishonor and bankruptcy.
That's why it's District of Columbia.
Yep.
Columbia is the king of the ocean, et cetera, all the songs that come out of England. So that was
Yep.
my question. So the territory of the federal national government, which is Washington, D.C., post office, military bases, things like that?
Yes.
Okay, great. Thanks.
Okay. So the term for an international bankruptcy is 70 years. Okay. So 70 years after 1789, we get into the year 1859. Does anyone know what happened in 1859?
Civil War.
Civil War. Okay. The reason for the Civil War, the real reason. Okay. Slavery was already on its way out. For those of you who know and know international treaty and what was going on around the world at the time, it had already been outlawed internationally. So basically, America was in the process of following suit. But it was, at the end of the bankruptcy, the debt is due. Okay? And the states signed on as sureties on the Constitution saying they would pay the debt. Okay? So King of England, through his bankers and Rothschild's Bank of France, basically said, okay, debt's due. You states said you'd be surety. We want our money. And the southern states, or the northern states, went to the southern states and said, basically, you guys have all the money. You have all the gold. You have all the cotton. You have all the resources. You have all the wealth. The material wealth of our nation was pretty much wrapped up in the South. And the South said, yeah, no, we're not going to pay the debt. We're going to start our own country. And because of their dishonor with the international bankers, it was now up to the North it was the will of the creditors to get the debt paid or to take sureties for the debt. So, basically, we fight a war, end of the war. What gets resolved is now the states have lost their sovereignty because the states, refusing to pay their debt to the creditors, started another 70-year process, another bankruptcy. Okay, we didn't pay our old bankruptcy, so now we're going into another bankruptcy, except this time they're going to take away something else. The first bankruptcy, they took away the nation's sovereignty. They took that away because of how? Because the national government no longer could control its property. Whoever holds legal title controls the property. Okay, but now the states were in dishonor. So the international creditors were now taking control of the state's property. Okay? So the states no longer have their sovereignty because they don't control their property. That's the only thing that distinguishes a sovereign from someone who is not a sovereign. If If you're a debtor, you're not sovereign. Creditor controls. Okay?
Sorry, did you skip over 1812 and 1811 on purpose?
I can talk about 1812, but it wasn't. Right now I'm doing the bankruptcy cycles.
Got it, okay.
We'll talk about that. That's a good one too, because of the War of 1812.
Well, it was just, the way it was explained to me, how you explained it was, that was kind of the foundation of the next thing that was going to happen. It was
Well, the War of 1812 was, okay, remember we had the Constitution in 1789.
Right.
And in 1791, Alexander Hamilton created the Bank of the United States. Bank of the United States is where the securities were being held. So basically the international creditors, wanting a guarantee of payment, said, okay, you hold your securities in this Bank of the United States, and we're all good. Okay? The Bank of the United States had a 20-year charter. So fast forward 20 years, 1811, and Congress decided, no, we're not going to renew the Bank of the United States. We're going to get rid of it. Okay, it wasn't a real popular thing anyways. Again, pissed off the creditors. Creditors basically, at that point, said, no, you don't. And they sent their troops in. So we had British troops on American soil. And they burned the White House and took possession of all the federal courts. Now, why would they take possession of the federal courts? That's where the titles are. They're taking control of the titles. Okay? As long as they control the property, that's all they care about. So after they burned the White House and took control of the property, we decided we'd renew the Bank of the United States. And they left. Okay, so 1859, second bankruptcy, states lose their sovereignty. Fast forward 70 years, 1929. What happened in 1929? Stock market crashed. Okay. What happened in 1929? The debt became due. Actually, let's go back 20 years before that, because they were already in preparation. Has anyone ever heard of the Federal Reserve Amendment and the Income Tax Amendment and Jekyll Island? Okay. In Jekyll Island, the international bankers, along with the Secretary of Treasury, got together in 1909 and said, okay, how are we going to handle this? In 20 years, this debt is due, and we don't have the money to pay it. So, what are we going to do? And they came up with the Federal Reserve System. Okay? And the Federal Reserve System and the tax collectors. Does anyone know like the stories of, let me think, actually, let's go back to the Bible. In the Bible, who were the tax collectors for Rome? Were they the Romans? Or were they the people of the territory that they had taken control of? The people of the territories, right. Now, so the tax collectors, even though they're working for a foreign power, they are your people. You don't send in foreign tax collectors, okay? So the IRS, even though it's made up of U.S. citizens, is working for a foreign power, okay? What do taxes go to? What does your income tax pay?
Interest on the debt, interest on the national debt.
Does it pay for the operations of government?
No.
No, it does not pay for the operations of government. It's going to the creditors. Creditors get the tax. Okay? So 1929 rolls around and bankruptcy's due, and we don't pay. We go into another dishonor. This time,
How much money are we talking about? I mean, like I said, look, your monthly payment is $755 billion.
the first, I believe the first bankruptcy, 1789, it was around 13 million. Back then, which probably was a lot more than 13 million now.
Like,
The creditors got their payment. The creditors for the Revolutionary War got paid by the Rothschild Bank of France, okay, Bank of Paris. So Rothschild paid the creditors, but now Rothschild had a security interest in the national government, okay? So that's basically what went down then. I don't know the amount and what it was up to the Civil War.
It's the buy-in to the Federal Reserve System was $500 million at that time.
Okay, so that's in 1913.
Because the discussion has been now, which has been brought up by Ron Paul, when the bankruptcy occurred the last time, there were people seriously on the inside saying we could buy out of the Federal Reserve System for the same $500 million. And there's a serious discussion going on behind the scenes as whether or not that would happen. If that was to happen, every international bank would collapse, it would cause world chaos.
Yeah, and we don't want that.
So people behind the scenes said, we're not going to do it right now, but there was serious talk about them maybe doing it. So.
Yeah, you won't see the Federal Reserve System go anywhere unless it changes its name. That's all that'll happen. It's not going anywhere. It's the only way the creditors have a security is through the Federal Reserve. Okay, so 1929, they had already taken the state's sovereignty. They had already taken the national government's sovereignty. Whose sovereignty did they take in 1929? The people. And how was that demonstrated? Well, Social Security came around in 1933.
Conversation of gold and silver?
Confiscation of all the gold and silver and all legal title. Up until 1933, you could hold legal title on your property. It was called alloidial title. If you used gold to purchase your property, the property was yours. You had control over the property. But now, because the people are in dishonor and the people are bankrupt, they no longer control their property. Now, all this history that we're going through, I'm not giving this to you to say it's bad or it's good. It's just what is. And it's actually good, believe it or not. I know this infuriates a lot of people to hear that how things actually work, but I'm here to tell you that everything's been set up this way for your benefit, okay? And when you understand how to be a creditor in that system, you'll see how powerful it is. That our old system of law, being in the Republic, being under common law, being under execution of law, is not a good place to be. It's much more destructive, okay?
Can you explain alloidial title, please?
Alloidial title is basically, remember we talked about how title was split into equitable title, legal title? Alloidial title is one and the same. Legal and equitable are no different. It's one title.
It gives you sovereignty over the land. It's in the California State Constitution under mining title, as an example, because you can control what's underneath the land, what's above it, but it also means you don't come under codes, covenants. If you want to build a garage or an extension on your property, you got to go through commissions and whatever else because they control your property.
Right.
And it was actually written into the California State Constitution because miners would work a piece of property, go into the bank and say, hey, Eureka, I got a bunch of gold, and then the creditors would come take the property away. So allodial title was written into the California State Constitution, but good luck filing an allodial title on your property because it's almost impossible.
Right. Okay.
So it gives you total control and sovereignty, right, Brandon?
Yes, gives you control. That's basically a creditor controls. Plain and simple. If you control, you have legal title. Whether you've got a document or not, if you control the property, you have legal title. You are sovereign. The property is sovereign. Okay?
Would having a little title on your property mean they couldn't charge you, say, property taxes?
You wouldn't be on the grid. If you took your grant deed, accepted it for value, and gave it back to the county, you'd be removed from the assessor's parcel numbering system. Your property is no longer on the grid. There's no longer a property tax on that property. Now, I'm not saying anybody go and do that because you need to be responsible for the property. That means bonding for sewage, bonding the police department, the fire department, any benefits and privileges that your property receives, you now become responsible for. You were paying the property tax because the state or the county took responsibility for those things. Okay?
Is that like common law, or what kind of law is that?
It is what?
You know, when we receive benefits and everything, like...
It is the current common law, but common law now is admiralty.
Yeah, when you talk about the years and what happens, can you talk about the law that everyone is subject to for the land, whether it's common law, admiralty law?
You're not subject to anything except by volunteering and by agreement. Okay? When you lost your sovereignty and your ability to pay your bills, they actually gave you something in exchange. And every time they take something, they have to give you something of equal or greater value, otherwise they're committing a crime. And what they gave you in 1933 was everyone over here in jurisdiction A now has an exemption. You're a creditor, okay? Now, from the perspective of jurisdiction B, you're a debtor. Okay, here I'll do a little breakdown of the public trust and the private trust. easier to see. Okay. That's not too good. Anyone familiar with trusts in here? Okay. For those of you who are not familiar with trusts, let me give you the sweet and simple. A trust has basically 4 essential parts: a grantor, a trustee, a beneficiary, and res, which is the thing of the trust, okay? Or the property.
Could you say one more time?
Grantor, trustee, beneficiary, which are the 3 positions in a trust, and the res, or the property of the trust. Corpus is another word for it. Okay. So, we'll call this up here at the top, we'll call this the private trust. And we'll call this trust down here on the bottom, we'll call this the public trust. Okay. So in 1933, they took your title. Not only that, not only did they take title to your land and take away your ability to pay your debts with real money, but they also took title to something else, your body.
Right.
Okay? And that was done through a certificate of title known as a birth certificate. Okay? That birth certificate is the title to your body. Okay? Now you can take legal title of your body back. They were only doing it to give you a benefit. Like you're basically, based on their perspective, you're a bunch of you're a bunch of irresponsible people. That's how they look at it.
You're slaves.
Yeah. So if you want to be irresponsible, we'll let you be irresponsible. But what we're going to do is we're going to put you into this trust here so that we control these irresponsible slaves on the plantation. Okay? So, this is the grantor. This is the trustee. This is the beneficiary. And same down here. Grantor, trustee, beneficiary. Okay. Grantor of the private trust is living men and women. Okay? The trustee of the private trust is a foreign situs trust that is created and evidenced by the birth certificate. We'll get into that in a minute, how the birth certificate works and how it works with titles and everything. So there's a foreign situs trust that was established with your birth certificate. Okay? And when I say foreign, I mean foreign to jurisdiction B, foreign to the democracy. In order for them to create this government on top of a government, they had to first recognize the people over here and say, hey, you're the source of all the energy. You're the source of all the production. So we need to have a legal identity for you in jurisdiction A. Okay? Remember, jurisdiction A is the private or the republic. So that is a legal entity. Okay? And that legal entity we'll call, a lot of people like to call it the straw man. I'll just call it the private trust. Or the, no, that's not good because we're talking about trust here. We'll call it the foreign situs trust. Well, there's 2 different straw men, so I don't want to call it a straw man yet. Okay, so we'll call it a foreign situs trust.
The person?
The trustee is a foreign situs trust. Okay. The beneficiaries of the private trust, yes?
I'm not real clear on your definition yet of the foreign situs trust.
A foreign situs trust is an entity that is foreign from jurisdiction B, from the democracy.
So it's just a separation again.
Yes. Okay. It's the legal identity that's on your birth certificate. Typically, the birth certificate will be in upper and lower case for your name.
Oh, okay. So
Okay, so it's a separate legal identity from the U.S. citizen that gets created. Okay, beneficiaries of the private trust are the public trust, public entities, the government, U.S. citizens, corporations. Those are the beneficiaries of the private trust. Okay. Down here in the public trust, the grantor is a position that kind of weighs. You're either the grantor or someone steps up to be a grantor. There is no designated grantor. Trustees of the public trust are public officials, judges, attorneys, any government agents of any kind. Beneficiaries, debtors, of the public trust are the people. These guys.
Beneficiary, what's the benefit?
You get the benefit of what the corporations are doing for you.
Okay, corporation meaning the government.
Yeah.
Got it.
Trustees, the public trust is the government. That's jurisdiction B, right? Jurisdiction B down here, jurisdiction A up here. And notice how it's a mirror reflection of what's going on up here. Okay? So, who controls a trust?
The trustee.
Trustee. Who determines the duties of the trustee?
The maker.
The maker, the grantor. Okay? So, if the grantor creates the trust, the trustee controls the trust. Okay, so this guy here was born into the world, and the law form that we're all operating under is known as admiralty. Is everyone familiar with that term? Admiralty, maritime law. The reason we're in admiralty is because admiralty has grace and mercy. It's the superior law form. Okay? Common law is execution on the law. Okay? If you go back to the Bible, in Genesis, actually, they talk about, or God gives Adam and Eve in the non-commercial zone, he gives them the law, which is everything is yours. There's no commercial transactions here. There is no payment. You take what you take. You give what you give. And, yeah.
When you listed the 5 law forms to start out with, you didn't list admiralty on there? So
Admiralty falls into, it can be commercial law, and it could be common law. Because currently the common law is admiralty. Okay? Admiralty is the law of vessels. And back in the 1600s, they got all existential on the law, and they said, yeah, we're all vessels in the sea of space. Okay, so Lord Mansfield in 1753 decided, yep, admiralty is now part of the common law. Okay, so in order for you to operate in admiralty, they need to give you a birth. A B-E-R-T-H. A birth in admiralty. And that birth, your mom filled out an application for a birth certificate. Application had your little feet print on it and everything. So what she does is she fills out the application, and they approve you. Yeah?
Is that birth application, is birth spelled B-R-T-H on that?
It's spelled B-I-R-T-H,
Okay.
but it's the same meaning. It's just like a birth. What's that?
The birth in admiralty law is spelled with an I?
Yeah. No. Just on the birth certificate.
Got it.
Okay. If they spelled it with an E, they'd be giving away what's going on. Yeah. So you get a birth certificate. Birth certificate is your foreign situs trust. Okay, it's what gives you the ability to operate with all the other vessels. If your vessel doesn't have a berth in commerce, then your vessel can't interact with other vessels. Okay, but this vessel is foreign to jurisdiction B, or the democracy. Okay? So, they created the birth certificate, and then corporation came along. This corporation, which was established around 1859, known as the Federal Corporation. And the Federal Corporation said, hey, we've got all these benefits and privileges for our members. We call those members U.S. citizens. Okay? They offered you benefits and privileges. These benefits and privileges came across came in the form of your Social Security or your social insurance contract. Okay? When you signed on for social insurance, you said, yeah, I'll take your benefits and privileges, and created another trust. This trust we'll call a cesticate trust, an implied trust. Okay? And this implied trust now gives you benefits and privileges. Not only are you able to interact with all the other trusts out here, but you get the benefits and privileges of being a debtor in the United States, which is you don't have to pay. There is no gold anyways. There is no real money for you to pay for anything. But the benefits and privileges are you get to operate in commerce, you get to go to jail to pay your debts and things like that. Okay? In the common law, there is no debtor's prison. Okay? But in commerce and admiralty, there's debtor's prison. And so your benefit is to serve jail time to pay your debt. That's one of the benefits of working in commerce. If we were in common law, okay, not in commercial law, what would the rights of the creditor be if you owed me a debt? I could force you to work off that debt with me. That's how common law works. It's execution on the law. Okay? Actually, let me get back to the story I was telling about the Adam and Eve in the Garden of Eden. Garden of Eden was a non-commercial zone. Okay? There was no money. But as soon as Adam and Eve broke the law, and God told them beforehand, if you touch the fruit, you will surely die. He gave, here's the restriction, here's the punishment. Okay. Did he kill Adam and Eve when they touched the fruit? No. He switched law forms on them. He switched to admiralty. He switched to grace and mercy. He's like, okay, I know I said I was going to kill you, but instead, we're going to go into a commercial law form. We're no longer in law of the land. Okay, and in this commercial law form, you get to discharge your debts. Meaning, I get to put my debts off into the future. Okay? So he basically said, okay, here's the they came to him with, what did they put on? When they, after fig leaves. So they said, okay, we're going to pay with fig leaves. God says, no, no, no. Creditor determines the money.
Was Adam and Eve operating in bankruptcy at that time?
Not yet. They were entering bankruptcy at this time. Okay? So Adam and Eve, because basically if you don't pay your debt, you're in bankruptcy. Okay? And Adam and Eve were given the ability to discharge. Now, discharge does not eliminate the debt. It puts it off into some future time. Okay? So the money that the creditor chose, God, he said, no, 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 the money is going to be the blood of animals. Okay? Sacrifice of animals, that's going to be the money. That's how you're going to pay your debt to me. Okay? So he gave them the ability to discharge. Okay? So they move into the commercial zone. And from that point forward, we've been operating under, or from that point until Jesus, they operated under what we would call discharge. Okay? Jesus came up with a new concept, or at least those who wrote the religion based on him did. And this new concept was prepayment. You ever heard Jesus died for your sins? Sins are debts. He prepaid your debt. So we're not putting the debt off into the future now. We're prepaying it. We're saying the debt's already paid. Okay? So this new system of law, we have redemption, right? We talk about redemption in the New Testament. Well, this is commercial redemption, and that's what they were giving you with this New Testament, this new contract. Okay, we're no longer operating under execution of the law. We're going to operate in a commercial zone where there's prepayment of all debts. Okay? So in 1933, remember I said they can't take anything without giving you something of equal or greater value? So what they gave you was the ability to set off your debts. Okay? You no longer, the debts are now prepaid. Okay? Everything in your society is prepaid. Where does money come from? Does anyone know?
Printing press.
Whatever an individual, another person contract, or saves money, or
Close.
Energy. It's a trade.
Your signature. Your signature creates all the money. If there aren't, since all corporations are dead things, they're all vessels with all capital names. Everyone knows that, right? Anything with a name in all capital letters is a vessel. Okay. All corporations are vessels. They're dead. They don't have the ability to create money. Only you do. Okay? So when you sign a promissory note for your house, you're creating money. Those funds actually go straight to an escrow account. Okay? You actually paid for the house. Now, the bank in their infinite greed don't tell you that. But if you knew as a creditor how to interact with the IRS, you could discharge that debt. Because, yeah.
do you offset it or discharge it?
You discharge it. You can set it off, but there's no debt. See, you paid for it. They tricked you into a new contract, which basically says, yeah, I'm going to pay you money, even though I just paid you all the money. And the wisdom in this system is that if you're a debtor, you're going to have to work harder and harder, right? Now, the system is a balance, okay? If everyone was responsible and everyone was a creditor, there would be no money. We would all walk around and just sign our names to pay for things. But the fact is there are debtors and people who refuse to take responsibility. And in that system, you can't tell, okay, you debtors, this is how things work, and then we come over here and say, okay, creditors, this is really how things work. Okay, we just have to assume you're all debtors. Okay, and if you're all debtors, then you're under the slave system. You're controlled. Title to your body is being held. Okay? Yeah?
Let me fill in a quick blank here and just ask you a question on it, because this is what made it really clear to me when we were going through all this whole process. If you guys want to look up, it's House Joint Resolution, or HJR 192 of June 5th, 1933. That's when they took away the right to that's when they took away everybody's rights. That's when they said you can't own gold or silver. But what they did, and this is really cool because it's Metaphysics 101, they changed the money system to the faith, spirit, and energy of the people of the United States, which means...
Yeah, that's what they gave you in return.
The system is the only thing of value is the earth. All of you are movable bags of earth and water, okay? And faith...
Untaxed water.
Untaxed water. Faith means you believe a monetary system exists. The spirit means you think up ways to create value. And the energy is that you move your arms and legs around to create the value in the society.
Right.
That's the law. That's in the law. So they changed it to a metaphysical faith, energy, spirit concept.
Yeah.
June 5th, 1933. And they said, you don't get to own gold or silver anymore. But now we're going to, I think, in some ways, a higher plane or higher level, faith, energy, spirit.
Yeah, no, we are. Like I said, none of the things that have happened are bad.
But that's
it's
also,
all good.
Isn't that what that's what allows you? Because you made this point the other night when we had dinner. You have the credit as the creditor. The bank stands in your way. Why don't you just explain that you explained the other day?
Yeah, well, they assume you're a debtor, okay? And in the world of debtors, we've put a financial intermediary in place, and that's the banks. The banks block you from your credit. You sign it and you create it. If you endorse a check, you created the funds for that check.
Doesn't allow them to create it out of nothing, right?
Exactly. You've authorized the bank to create funds out of nothing. Okay?
That's why I'll never deposit without
a signature.
Yeah,
Yeah.
you couldn't deposit anything if there wasn't a signature on there. Okay?
It's just wasted
Except
stuff, just
for a
wasted.
money order. But a money order is actually backed by gold. I don't know if you guys knew that.
People should probably take out the magnifying glass and take a look at the line. The bottom line that you sign on every check is a series of words.
Yeah.
It says
Authorized.
Authorized signature, security.
You're an authorized representative of the bank. It's the bank's money. As soon as you deposed yourself of the funds by depositing it in an account, you gave them possession of the money. It's their money now. But you're the one authorizing the creation of the money. Without you, the bank couldn't create money. The Federal Reserve can't create money. The government can't create
So you're
money.
the grantor and the trustee, and they're the beneficiary?
In a deposit situation,
Yeah.
in a deposit situation, you're the grantor, they take on the role as trustee. You're a trustee because when you sign a check, you're an authorized representative of the bank.
Thank you.
You're working for the bank whenever you sign your check.
So when you take a check in for somebody else, and they stamp it for deposit only, no one signed it, what's the deal there? How's that work?
That's an endorsement. It's a corporate endorsement.
Didn't you say that we're not allowed to own gold at a certain date? So how
1974 is
can
usually-
we have this kind of contract where gold can be the reimbursement you get for like a money? How can that work if we can't take gold
They-
or own gold?
Right, because the post office, the one who issues the money, and this is only postal money orders, by the way. The post office actually operates in jurisdiction A and B. Actually, the post office is in jurisdiction A. The postal service is in jurisdiction B. Okay?
Say that one again.
The post office, which was created before the government, exists in jurisdiction A, the republic. The postal service exists in jurisdiction B, the democracy.
My understanding is the post office is no longer a government agency.
They're both.
The post office is not part of the democracy, but the postal service is.
Okay.
Okay.
So they do both functions.
They operate in the private and the public. They're the only agency that has that ability.
When was the Postal Service created?
When was the what?
Postal Service created
Probably about 1933, 1935.
in one of those acts?
Yeah. FDR.
You mean the corporate postal service?
Yeah.
This constitutional one was Ben Franklin.
That was post office.
First office, okay, all right.
Yep. Post office was created by Benjamin Franklin, first postmaster general. That's why he's on the $100 stamp.
When does all this UCC, Uniform Commercial Code, come into play?
It's in play all around you. That's what's going on.
Is that embedded in Admiralty?
It is. You can't really separate them. UCC is really just the laws that the states have adopted for interacting in international commerce. Remember when we had our list of law forms? And commercial law was right there under natural law? Well, that's where if you're operating up there in commercial law, for you to perfect a security interest, they had to adopt laws that as a foreign creditor, I need to be able to come into your democracy and take control of property in your democracy. That's why they had to adopt the UCC. The UCC is for us, the foreign creditors, for you to come in and say, yep, that's mine, and nobody has a superior claim to me. Okay? Basically, the concepts of commerce and where we're going to go in future classes is there's like three elements to commerce. And there's the claim. There's the claim or title. Okay? That's one thing we need to learn how to do, is perfect our claims. Okay? Once you've learned how to perfect a claim and to get title, well, then we move into the different procedures. Okay? But realistically, without a claim, without title, the UCC itself, like people who use the UCC1 financing statement, is just a public notice. If you don't have a claim from jurisdiction A, it's pointless for you to do a UCC1 filing. Okay, and those of you who aren't familiar with UCC, UCC1 financing statement is a way for a foreign creditor to perfect or to put into the public record their security interest. So, for instance, I have a security interest on a piece of real property. I will go down to the county because it's the county records that are involved with real property, and I will file a UCC1 financing statement that lists the real property as collateral, has me as the creditor, and whoever the grantor or the trustor or the owner-debtor as the debtor on the UCC1 financing statement. So that's the three essential elements on a financing statement: creditor or secured party, debtor, and collateral. And it's just a public notice. It's your claim that has all the weight, but your claim you never put into public. Do we have to stop? Okay. All right, we need to switch the tape out.
I got about 5 minutes.
Oh, 5 more minutes, and then we're switching the tape. Okay, gotcha. All right, so that's one of the things we'll be going over in here, is not today, because we just want to get the foundation out, but you need to learn how to perfect a claim. That is the most important part of operating in commerce. Once you know how to get a claim, your power is unlimited. That's why the philosophy behind this particular class is how to be a creditor, because as a creditor you control. How many people feel that the government and the current economic system is deficient? And how many of you take responsibility for that? Okay, those are your creditors. Okay? Those who take responsibility for it, because you have unlimited power in this commercial system. You really can do whatever you want as long as it's not hurting or damaging anyone else.
Then they wouldn't be a creditor if they were.
Exactly. If you're hurting or damaging, you're not really a creditor.
On a dollar bill, it has the people's signatures, the Secretary of Treasury or whatever, right?
Mm-hmm.
Does his, or in the future her signature, does that create the money? Would that not be a currency without a signature on that?
It's not really currency. A Federal Reserve note. A Federal Reserve note is remember, we're in Admiralty. It's a negotiable instrument, okay? And it's actually an improper negotiable instrument. If you go through the negotiable instrument law, it's not sufficient to qualify as a negotiable instrument. But remember over here, they said, hey, if you want to be a member of this, you get special benefits and privileges. One of those benefits and privileges is the benefit and privilege of trading that worthless paper. Okay, you get to carry this worthless paper around and you get to give it to other people, even though it's not a proper negotiable instrument.
That would sound harmful to me,
What do you mean harmful?
trading worthless paper.
That's what you're doing.
Yeah, it sounds like a harmful act, and like it wouldn't be a legal thing to do.
Why?
Because people are in good faith thinking that it's worth something and it's not.
Well, if we agree that it's worth something, doesn't that make it worth something?
Faith, energy, spirit.
Yeah.
Trading with the enemy.
Trading with the enemy. Who said that?
I like that.
That's why in jurisdiction B they can't acknowledge jurisdiction A. If jurisdiction B recognized jurisdiction A, all judges, attorneys, they'd have to be executed. No, it's no. No, they're the watchmen's on the wall. They're here to help you. Believe it or not, they're here to help you. So they can't acknowledge jurisdiction A.
So we're all operating in fraud?
In some sense, but really, it's just uninformed. If you understand what you're doing, it's not really a fraud. They've made you believe that it's a republic and that the Constitution is what our laws are based on, but that's not the case. It's commercial law. Creditors make the rules. So when you walk into a court, the only thing the judge is trying to determine, are you a creditor or are you a debtor? If you're a creditor, he's going to find in your favor. If you're a debtor, he's not going to find in your favor.
What makes a creditor a debtor?
What makes a creditor a debtor? He determines by your actions, not by your words. You can't go, oh, sir, I'm a creditor. He's like, oh, you're a creditor? Perfect. You know, he's not going to find in your favor by what you say. He's going to find in your favor by how you act. A creditor is always at peace, is always bringing a solution.
Not arguing.
Not arguing. Okay? If you're arguing, you're in commercial warfare. You're a debtor. Okay? So it's all in your actions. Everything you do, the way you speak, you'll start to notice, and this is a heavy concept that we go into a lot on our weekly calls, and we'll do in this class, is being a creditor is a state of mind. And once you really get being a creditor, you'll have no fear. You won't fear anything because you'll know exactly how to interact with all those things that have made you fear. Okay. Go ahead and we'll switch it.
Contact you. And we're also going to be doing a weekly class on Thursdays. We don't have a start date for it yet, but also make sure you leave me name, address, or name, email, and phone number, because we want to do a weekly class here so we can all learn about this awesome stuff and do it the right way. So, and I will keep the store open afterwards too if people want to browse around a little bit. We might kick you out at midnight, but so I'll turn it back over to Brandon.
All right.
Thank you.
Yay.
All right. Any questions with what we've gone over so far?
Somebody had one question about why does the father sign the birth certificate?
Why doesn't he?
Yeah.
Admiralty is feminine law. We're no longer under masculine law.
So does
Now,
does
but
that
the
having natural
father can put a claim in on his child,
Okay.
and that claim, like did you guys hear about recently something in Texas, with the Latter-day Saints or something? And there were no birth certificates or anything on the kids, so realistically the state didn't have title to those kids. So how is it the state went in and grabbed those kids? Abandonment. In Admiralty, you have abandonment of property. If nobody puts a claim on the kids, the property's been abandoned. If the fathers would have went into the county court or the county recorder and filed a claim on the kids, state couldn't touch those kids.
Would that be UCC 1 or just
Yeah, you can do it on a UCC 1.
All right.
Can you do that just for your regular kids too?
Yeah. Your regular kids. As opposed to the irregular kids. Yeah.
In Minnesota, there's two different birth documents, one called the certificate of live birth and one is called the birth certificate. Is that true in most states or what is it?
I'm not familiar with how the states run it. Only one of them is a bond and goes to the Department of Commerce.
Well, Nebraska has that thing where you can just drop your kids off at the hospital and they just take them. They just take care of them. And I think they stopped it because the University of Nebraska dropped off their whole football team.
There was a woman at the Jack Smith seminar this October in Massachusetts, and she told the story about after her son was born, the governor of the state sent her a thank you letter. And it's the governor who sends in the birth certificate to the Department of Commerce. So I thought that was kind of interesting. Thanks for giving us some more credit. Because remember, it's those commercial bodies that they make the money out of.
Can you actually get to go see your real birth certificate?
No, it's a negotiable instrument. It's like trying to get the original note on your house.
So there
was one guy who's a rumor, legend, urban myth that supposedly got his original birth certificate and it was stamped by 17 foreign banks.
Yeah, I wouldn't want it.
Yeah.
You want it where it's at. Because it goes from the Department of Commerce to some international. Realistically, it doesn't have to go anywhere. It might be with the Secretary of State of California for all I know. Because realistically, it doesn't have to go anywhere for them to have their security interests. It just has to be being held by their agents. The Secretary of State is under the Secretary of State of the United States, and the Secretary of State, the Secretary of Treasury, and the Attorney General expatriate their U.S. citizenship. Do you know why they do that?
No.
So they can work for the foreign corp.
So they can work for the foreign corps. Okay, they have to be able to work for the creditors.
When do they repatriate?
Probably after their term. The U.S. Code. It's actually in the U.S. Code. In the U.S. Code, you'll find.
Isn't there actually, like when we're born, as a birth certificate, isn't it marked for a certain price? Like, so, like it's $1 million per person?
No.
It's a pooled account, so I wouldn't say that there's a direct value put on it. Realistically, the value would be all the property and gold that was confiscated. Divide that up by the number of people in the United States, and that's your share, plus interest, since 1933.
I heard that they bond these birth certificates, right? Or make it a security, or it's a tradable thing.
It is a bond, yes.
And is it? I heard that it's traded on a securities exchange somewhere. Is that correct?
It's not necessarily traded, not on the open market. There's typically 2 ledgers in any corporation, and there's going to be what we would call the private ledger. And in the private ledgers where you would put assets, it would be on the asset column of someone's ledger. Some international banker, bank, international entity, someone who's a creditor.
Brandon, the guys online requested that the questions be asked on the mic.
Okay. Yeah, let's do that. If you have a question, we can pass you the mic. Any more?
I don't know if this is part of your case plan or not. Can they hear me on the internet with this?
Yeah.
Yeah.
If you don't want to talk about this is totally cool, but I'm really interested in the whole thing with Obama. And again, the question becomes whether or not he's a citizen or not a citizen. The Supreme Court didn't hear it, but after he takes the oath of office, it'll be represented to the court with a claim of supposed damages. And you said, and this has been swirling around in my mind for quite some time, that the President of the United States takes a corporate oath to the foreign corporation,
To democracy.
which means the CEO can make anybody they want. He doesn't really even have to be a citizen to be the CEO. And at the same time, he takes an oath to the republic, which he has to be a natural born citizen under the Constitution. And
There is no more.
and
There
that
is
makes
no
him-
more Constitution.
That makes him head of the Joint Chiefs of Staff. That makes him commander in chief. What the Supreme Court is saying by not upholding the lower D'Onofrio and Byrd cases is that the Constitution isn't really in force at all, because they wouldn't uphold it until they say, well,
Who's the parties? Who are the parties on the Constitution?
the states.
The states. Are you a state?
No.
If we're a creditor and you're in jurisdiction A, do you care what they do in jurisdiction B?
No. But I am interested as to how you think he's going to get away with doing
Yeah,
it.
he'll get away with it because it
Doing
doesn't
one
matter.
oath
It's
and not doing the other oath.
the oaths don't matter. I'll tell you that. It's a democracy, and a democracy runs like a corporation. He can do whatever the hell he wants.
But he doesn't have to have power in public and private?
No, not the president. Secretary of State does.
Okay.
Remember, he's just head of the democracy. The military is the democracy. Remember, how many of you are familiar with the 213 amendments of the Constitution?
What?
The 213 amendments. Okay, there's a couple people. Okay, the first 13th amendment was no titles of nobility. Okay?
Right.
Titles of nobility are like esquire. Okay, they said no, attorneys cannot be part of this country or this government. Okay? The second 13th amendment got rid of slavery, involuntary servitude. And then they created a new government, which was the federal corporation, the democracy. And in that democracy, because it's a military democracy, if you look in the old Army manual from before 1933, a democracy was actually a very bad thing. It's a military-controlled government. Are there titles of nobility in the military? Yeah. The whole system's on rank, right? Okay? So they created a new class or a new title of nobility known as a U.S. citizen. A U.S. citizen is a title of nobility. And at that point, it was also okay for esquires to be part of the government. Okay? So we're operating, or the democracy is operating under the laws of tribunal, military tribunal. Okay, that's basically what's going on in the democracy. That's why it doesn't seem to work how you think it should work. When you go into court, you're guilty. By showing up, you're guilty. The hearing in the court is your first appeal. Okay? The moment you got charged, you were guilty. Have any of you ever seen that movie with Tom Cruise and You Can't Handle the Truth? You know, Few Good Men, that's it, Few Good Men. And remember, they made a big deal out of Tom Cruise even accusing, even asking the question if he had done this act, right? Because the act of an officer accusing is the judgment. Okay, so when an officer writes you a ticket, that's the judgment. That was your first hearing. When you show up to court, it's your first appeal. And you have a right to a hearing and to appeals. That's all you have a right to. Your first appeal is the court hearing. Then you could take it to an appellate court if it doesn't go your way. And then after that, they don't have to hear it. Okay? So basically, the democracy is run like a military tribunal. Creditors operate outside of the democracy. You cannot be a creditor inside the democracy, even though your straw man is your creditor in the democracy. Everything's backwards and mirror image in the democracy. So your U.S. citizen, that thing that from jurisdiction A, it's a debtor. But in jurisdiction B, the straw man is the creditor. And the living man, is the debtor. Okay?
So we're the straw man?
What's that?
Are we the straw man?
The straw man is a trust. It's a stack of papers. Realistically, if I call you by your name, that's not you. That's an identity, a legal identity. Okay? So no matter how you write your name or you spell your name, all uppercase, lowercase, all lowercase, hieroglyphics, however you want to write your name, it's fictional. You are not the name, you are not the title. The title is a fiction. Okay, we haven't really talked that much about fiction, but everything in commerce is fictional. Okay? Because everything interacting in commerce is dead or a vessel. Okay? So there is no positive law. Everything is through volunteering and agreement. And that's the basis of the control that you are subject to. You're only subject if you volunteer to be subject. Okay? So...
In jurisdiction B, then, if the straw man is the creditor.
Sorry, I forgot about the mic.
Leave one back there, he's got another
In
one.
jurisdiction B, then, if the straw man is the creditor, then shouldn't the UCC filing reflect that the straw man is the creditor?
Yes, it should, actually. Or realistically, it should be a bailor or bailee. Should be your UCC filing. If you're filing a UCC financing statement on yourself, you would want the straw man as the creditor. Because the straw man is the creditor, right? Isn't it the straw man's account that generates all the money? I mean, realistically, you can't interact with the democracy or jurisdiction B. Only the straw man can. So you're really a trustee for the straw man. The straw man is a trust, and you're the trustee. And I don't know how many of you are familiar with like the patriot movements that are out there, and there's people who go into court and, I'm not the straw man. That's not how I write my name, all uppercase. The judge isn't stupid. He knows you're not the straw man. But guess who's responsible? The trustee. And you are the trustee. And your body, because they hold the title on it, is going to be surety for that trust. So when they haul in the vessel, remember this is admiralty law, first thing you do is arrest the vessel, bring it into court, attach it as a surety to the charges, and then make a decision. Are you a debtor or are you a creditor? And we'll go from there. If you're the creditor, you're gonna put something up that's going to release the vessel. You're going to bond it, right? If you put up a bond, there's no need for the body to be a surety. The bond covers that. Okay? That's really what they're doing when they're holding the body. The body is the bond. It's the surety for the charge. And remember, the charge is fact. The fact that there's a charge right there means you are guilty. Does anyone actually know what you're doing when you plead guilty? Or where the word guilty comes from? Gilded It's from the Old English for gilded, which means to pay. Okay? So when you say I'm not guilty, no, first they ask you, do you understand the charges? They're not asking, like, do you understand English? Hello, can you understand what I'm saying? That's not what they're asking. What they're asking you is, will you stand under these charges? Are you going to be the surety for these charges? Yes, sir, I understand these charges. Okay, how do you plead? Not guilty. You just said you were going to be responsible, now you're saying you're not going to pay. You're in contempt. Immediately, you're in contempt. Dishonor. Okay? That's actually something we need to, I guess we should go into, is honor and dishonor.
But you don't say, I don't understand the charge.
When the judge asks you, do you understand these charges, and you say, no, I don't understand, does that put you back into...
It puts you into being a debtor. Because now you're blocking. You're not acting as a creditor. You're not bringing a solution. You're actually delaying the judge from getting done what he needs to get done.
So then what would be the response?
Yeah, I understand. I'll stand under these.
Just take care of it.
Yeah.
Settle it.
And I plead guilty to the facts.
See, I think...
See, people get in their head that pleading guilty is something bad.
Right, that's what I was just...
You're saying, I'm paying. I'm going to plead guilty to the facts. I'm going to waive any benefits and privileges of prison. And I'm going to effect payment immediately. Because now I'm in honor. And they can't put a person in honor in jail. You've honored the agreement. You've volunteered to be surety, and as surety, you're bringing a bond. Or you're going to underwrite those charges. Okay? Anything else? Okay. Yeah.
What's the difference between surety and security?
What's the difference between surety and
It sounds like,
security?
Something is surety, but it sounds like security. You know, you're putting up security or something.
Okay. Well, if something is secured, like a debt can be secured by collateral. Okay. And realistically, that is surety for the payment. Were the states secured, or were they being sureties? It depends on really how you're using the word security. I wouldn't use it to mean surety, but a surety means that's the source of payment. The surety is, the guarantor is the surety. The surety is the guarantor. So just like when you co-sign for Little Billy to get his car, you're the surety. You're the guarantor on the loan, even though Little Billy's credit paid for it up front. Okay, anything else? Yep.
Hey, Braden. This is all fascinating. Some of this is new to me. I say this is very fascinating. Some of this is new to me, some of it's not. But a big part of me is saying, where are we going with all of this? What practical benefit? What, what are the advantages? What follows? What does one need to learn in addition? Do we become experts in admiralty law?
Yes, you will become experts in commerce.
Right.
And by becoming an expert in commerce, you can be a creditor, and creditors control. So if the world isn't exactly like how you think it should be, well then now it's your opportunity to take responsibility, step up, and change it. That's what I'm bringing to you. The ability for us to stand for our community and to make it into the community that we want, because we have that power. We've been irresponsible. The whole world. Most of the people in the world are completely irresponsible. And if we step up and take responsibility, you won't no longer be crying to jurisdiction B for them to fix all your problems. And just like everyone was so jazzed about bringing Obama in, well, everyone was jazzed about bringing FDR in too. Okay? And they're no different. Obama's going to do the same thing. He's like, okay, you think government's the solution? All righty, here we go. More restrictions, because you're going to be paying, And if you're paying, we need to figure out a way to bring that revenue in. You want us to fix it. If you're going to jurisdiction B, the public, and you're saying, fix our problems, they're like, okay, we're going to give you some more benefits, but we're going to restrict you. We're going to control even more aspects of your life now. You think they were controlling a lot up until now. Wait until this new level of bankruptcy. Because now, at 1929, 7 years later, 1999, second witness came around in 2008 with the financial collapse of 2008. And now, does anyone remember when the first vote on the bailout? Bush came to Congress and said, you know, are the people going to foot the bill? And through the representatives, over 20-1, people said, no way, we will not bail out Wall Street. We refuse to take responsibility. We're debtors. 3 days later, he goes back before Congress and says, well, will the corporation take responsibility? They're like, yeah, corporation will take responsibility. No problem. It's already secured by the international bankers anyways. But the Chinese wanted to make sure they can, because now the Chinese hold a huge security interest in the United States. They wanted to be able to guarantee that security, so they wrote in their own little clause there that now the Chinese military can come into the United States to protect their property, to protect their security interest.
What's going to happen when they foreclose?
Well, they won't foreclose, probably, unless we get belligerent. You know, it's when a nation gets belligerent that you send a military in, like what we did with Iraq. The whole Iraq war is purely commercial. If I can't protect my security interests in the country of Iraq, well then they're dishonoring the international commercial system. And if they're dishonoring the international commercial system, they're a wild card that we can't have. So we send in the military. We set up, what was the one thing they were trying to establish? Constitution, right? Wanted them to be a democracy. Because as soon as they have a constitution, the debt is guaranteed. The people are guaranteeing the debt by signing the Constitution. So that's what they want. And realistically, that's what the international bankers, the international controllers, they are bending over backwards to give you the best system possible. Believe it. It's all completely in alignment with universal law. That's why I'm not particularly religious. I don't actually belong to any religion or anything. But the Bible has multiple layers to it. One of those layers is a commercial layer. It is the entire commercial system laid out. And it's written in such a way that it's in alignment with the universal laws. You know, whether you believe in the Bible or not, I'm sure you've heard of what you put out there comes back. And when you do put something bad out there, it comes back 10 times. Okay? All those numbers in the Bible have a very specific meaning and a commercial corollary where we get all our commercial timelines. The seven years for bankruptcy, the 70 years for an international bankruptcy, 10 days for a commercial process, 3 days for a commercial process. All those numbers are in the Bible. And it's your commercial system. And as long as they're doing it by that system, they follow the Bible to the T. They're the sons of Cain. You guys remember the story of Cain and Abel? Okay? We had our very first tax protester, Cain. He pays his taxes with vegetables. God says, that ain't money, man. I told you. Money is the blood of an animal. Cain says, I'm a farmer. And actually, let me go back in Genesis a few chapters. God went to Cain and said, will you follow my law? What did Cain say? No, I ain't going to follow your law. He went to Abel. Will you follow my law? Yes, I will follow it to a T. I will follow your law. Did Abel follow the law? No. Cain follows the law to the T. And the sons of Cain are the ones who have been put in charge of you. The sons of Cain You don't see the religious system in your courts or in your system of commerce. They say, we don't follow God's law. And then they follow it to a T. But they follow that law to a T. They follow that commercial law that's been set forth in the Bible. And when Cain, the first tax protester, refused to pay with blood, or he didn't refuse, actually. He got approached by God. God said, no, this isn't proper payment. This is like when your parents came with fig leaves and tried to pay. We're not going to accept vegetables. Cain says, okay, so you want blood. Here you go. My brother. Right? Kills his brother. Says, that's what you said. You wanted blood. So God going, okay, well, he didn't exactly dishonor, but he's using stolen funds to pay his debt, right? So as a creditor, am I supposed to just take your stolen funds as payment? No. So here, we're back. Now he takes them into admiralty, gives them some mercy and some grace, and says, we're going to put off your debt. I'm not going to kill you now. And Cain said, well, yeah, that's all good and fine, but what about Abel's family? They're going to be pissed. And they're going to be after me. And God says, no, they won't. Because if they do, I'm going to return the retribution on them 10 times. So the correlation I'm making there is that the sons of Cain reject the law of God but follow it to a T. Sons of God say they're going to follow God's law and then don't. They're in dishonor. Sons of Cain know that it's about being in honor.
What's the sign or the mark that they put on Cain?
On a Cain?
On Cain.
Yeah, no. They also put a mark upon his stand.
Upon Cain. You know what the story is?
All men will hunt me.
Yeah.
And he says, because he's now an outsider.
Right.
So he says,
He's in jurisdiction A. He got moved from jurisdiction B into jurisdiction A. That's what happened.
And so all this falls in line with the King James Version, the approved version.
I would say it falls in line with all versions, even the Hebrew version.
Why is not the system of understanding all of this imprinted into our educational system? Why is there intentionally out of the entire educational loop so that people just follow into this being worthless, irresponsible?
Who's educating you?
Well, the state is supposed to be
Public. Jurisdiction B.
Schools in session, hide the kids.
Jurisdiction B is where you're getting your education, right?
Even private schools do it.
That's what they're jurisdiction B too. They call themselves private schools, but they're in jurisdiction B. So you're depending on jurisdiction B, which for its survival needs you to be a debtor. You think they're going to educate you to be a creditor. They would cease to exist. The fact that you depend on them for your education shows you're a debtor. You didn't get this from your parents. They didn't educate you.
I was just going to make a comment. Well, it's perfectly in line with law, which is if you're going to be it's perfectly in line with law. If you're going to be a creditor, you have to go out and get the information and be a creditor. You can't be expected to have it handed to you.
Exactly.
As you have to wake up and do it.
Exactly.
Comment.
So if we go the creditor route, if enough of us go to the creditor route, what's going to happen with the B? What do you think is gonna happen?
If everyone, no, it wouldn't always be there. If everyone was truly being a creditor, everything would be working, right? Because we wouldn't even need the Federal Reserve notes anymore. We wouldn't even need banks because we would all be giving. If everyone's giving, there's abundance and more than enough to go around. The fact is, we're not all giving. We're all living in some kind of limited state of mind that we're not coming from abundance. If we were coming from abundance, then we would take responsibility for our communities. We wouldn't say, please, government, make my community what I want it to be. Please, Mr. Police Officer, protect me. Please, Mr. Fireman, put out my fires. The fact is, we're not acting that way. And in order for the system to work, if there's a bunch of debtors, you need to keep the debtors in line. You need to keep the irresponsible people from completely destroying the system.
I guess what I'm asking is if we become creditors, do you see any repercussions from the B side on creditors? I mean, what's the
No, you control it.
brass tacks,
You control the B side. If you take all the people out of the corporations, what are the corporations going to do? Yeah. What can they do without people? Right? And if we're all loving our brother, honoring our brother, whether our brother is a policeman, whether our brother is an FBI agent, whether he's an IRS agent, whether he's a judge, whether he's an attorney, if we're honoring, do we need the corporation anymore? Remember, back in Genesis, where did we start out? Commercial-free zone. Walls protected by angels. Fact is, you're not ready for a commercial-free zone. That's the utopia everyone thinks they want. But greed puts you into the commercial zone. And as long as we're operating in the commercial zone, you're going to go by the rules of the commercial zone. Now, stepping up and being a creditor means this isn't a technology to make you above the law, although you are above their law. But realistically, to be a creditor, you need to be in honor with everyone. And if you're in honor and respecting and not coming from greed, there's no reason for them to touch you. You're making everything possible. You're the source. As soon as we get the mic back there.
Can you confirm that the Supreme Court ruled that admiralty law is the law of the country?
Can I prove that the Supreme Court... Well, realistically, before the Declaration of Independence, the admiralty law was part of the common law. But actually, that may even be the reason that we had the Revolutionary War. Lord Mansfield in 1753 decided admiralty is part of the common law. Because where does... in law of the land, there's no such thing as insurance. In law of the land, there is no such thing as negotiable instruments. The fact that you're using negotiable instruments, checks, credit cards, Federal Reserve notes, you're demonstrating to them that you know you're an admiralty. And you have social insurance. See, there was no such thing as insurance until law of the sea, admiralty. And basically the reason why admiralty came to be was, okay, we're going to, send this ship off and I'm funding it, but there's no guarantee that this ship will ever come back. It could sink. The captain and his crew could just make off somewhere, some island in the middle of the Pacific. We'll never see him again. So we have to be able to insure the vessel. And then negotiable instruments in international banking. We needed to be able to we didn't want to have to carry our gold with us everywhere we went to purchase something. Negotiable instruments are law of the sea. So you've been using it, and it's been being used. And it's not a bad thing. Like I said, it has grace and mercy. Law of the land doesn't. You don't want them executing on the law, believe me. You do not want that.
Can you talk about dishonor and honor?
Yes. Okay, everything in commerce comes from offers and acceptances. Okay? Let's go back to the traffic ticket. Cop pulls you over, writes you a ticket. That's an offer. Okay? Now, there's 3 paths I guess you could take. You can accept it. You can refuse it. Or you can do nothing. But maxim of law, doing nothing is dishonor. Okay? So, accepting and paying is the only way to be honorable with any offer. Anything else is a dishonor. Even a conditional acceptance in most cases is a dishonor. Okay? So, I mean, we could take any situation. Let's say you've got felony charges against you in court, which could lead to jail time. Okay? The charge is the offer. And the judge, in his private folder, not the public record, but the private record that's held in judges' chambers, has the charging instrument. It's a negotiable instrument with someone's signature on it, charging you. It's actually, if it's a traffic case, it's the ticket. Remember, the cop gave you a copy. He didn't give you the original. He gave you a copy. The original is the charging instrument. That is in the judge's folder. Okay? Now, do you understand the charges? Yes, I understand the charges. I will be surety for this. How do you plead? How are you going to pay? I'm going to pay. Gilded. Okay? If I do anything else, I'm in dishonor. Okay? A creditor is always in honor with all of his transactions. If you say something, you do it. That's being in honor. Being your word is being in honor. Did that answer it? Okay.
So what if you're wrongly or falsely accused in a situation?
Right.
Where's the honorable thing there?
Pay it. What do you mean wrongfully?
You weren't speeding, or you didn't, make a wrong turn as being charged by the officer.
What did you do in the initial hearing? You accepted. You agreed.
He says you're not pleading,
That's your second hearing. That's your appeal.
No, when he asks you something, he says you're not admitting guilt, this is just a promise to appear.
Because you can't be gilded until you show up to court, right? Until you send in your payment. Then you've admitted.
And you're saying the only honorable thing is to accept his offer. So even if he's wrong,
Yeah.
you just have to say, hey.
Officer's word. Officer's word. Remember, just like Tom Cruise, as soon as he states it, it's truth.
He's not, but the officer's not acting in honor.
From his perspective, he is. He thinks you were speeding.
Not necessarily.
Not necessarily, but it's a creditor isn't going to charge his brother. Okay? So remember we were talking about offer and acceptance and being in honor. If you charge your brother, then you're in commercial warfare. Let them charge you all day long. Jesus said, turn the other cheek. Let them charge you and pay it. They've given you this great thing. When they took away your right to property, they gave you something so much more valuable, which was the ability to discharge and to set off with your signature.
What about accept and redraft?
Accept and redraft? What do you mean by redraft?
Would that still be conditional?
It depends on what you mean by redraft. If you accept it and the terms of your payment carry something, I wouldn't say that's necessarily a reoffer or a redraft. You're saying, okay, I accept your charges, here's the payment. And the payment itself comes with its own terms and conditions. It's a new contract.
So maybe here's the disconnect here that I'm not getting. First off, you're saying that guilty and not guilty is gilded or not gilded. Is that a Black's Law definition? Because I'm under the impression that it's guile.
Remember, Black's Law is all jurisdiction B. That's all you're going to see in Black's Law.
Filled with guile? Are you guilty when you committed the crime, or were you not guilty and you committed the crime?
Why is it they have you plead not guilty instead of innocent?
Again, because it goes towards intent. If you hit somebody in the back and they fall down the stairs, were you filled with guile and you shoved them down the stairs? Were you not filled with guile when you hit the person in the back?
If they made the charge, did you do it? Whether you did it or not, if the charge exists.
Okay, and then so that's question one. The disconnect seems to be,
okay,
do you accept their charges based upon proof of claim? and say,
No.
I
That's-
accept
that's-
redraft
that's-
based upon proof of claim?
That's argument. Okay, here, just to give you guys an idea of
This
how.
is why people are confused.
No, I do. But I'm gonna try to alleviate that confusion right now.
You killed OJ's wife, or
Right.
something like that, it's or you killed so-and-so.
Okay, I'll try to give you some perspective on Jurisdiction B. Jurisdiction B is Disneyland. Okay? The facts are on the moon. They mean nothing. Elephants fly, and there's fairies and fairy dust, and okay?
Don't knock it.
Disneyland is not the place for facts. Okay? Facts don't exist in Disneyland. It's fiction. So, yeah, you may not be guilty because you were driving 70 in a 70-mile-an-hour zone, but the facts are on the moon. Fact is, you got charged. That's all that matters. You got charged. Doesn't matter if you did it or not.
Yes, but you could get falsely
Maybe
charged with
you
some
bring
crime.
up the word controversy and what it means and why we don't want to do it.
Yeah, good point. Yeah. in being in honor, in being in honor, and in being in dishonor, a controversy is created when you argue the facts. Okay? As a creditor, you will learn to establish the facts outside of Jurisdiction B. See, creditors operate over in Jurisdiction A. And in Jurisdiction A, when you've perfected your claim, you have the facts. Okay? So you never go into Jurisdiction B with an argument. If you go into Jurisdiction B with an argument or create a controversy, you're in dishonor. But if you bring your private or foreign judgment from Jurisdiction A and bring it into B and learn how to get it recognized in B, there's no facts in dispute. If there are no facts in dispute, there's no controversy and you're in honor.
Okay, I partly understand that. Let's say you go to an anti-whatever rally
Mm-hmm.
and you get labeled as a terrorist.
Okay.
You are now labeled as a terrorist. How do you plead guilty or not guilty? How do you handle something like that?
Everything's commercial. Everything's commercial. So if I get charged with being a terrorist, I pay the penal sum. I've got an actual charge against me. Like they brought me into court. You're a terrorist, and we're going to send you to Guantanamo.
Well, you
Yeah.
wouldn't even go to court.
You pay.
Just be taken it.
Yeah, you pay
Put
it.
away.
You pay it. You pay the
You're
charge.
leaving out the bonding process.
Yeah, I'm leaving out the details right now because we can spend weeks and weeks and weeks on the process and procedures.
Does remedy fit in here anywhere?
Yeah, this is your remedy. Your remedy is pay it.
Well, then what are our options to use for payment?
That will be in
That we'll get into in details. Bonding, you'll learn how to use negotiable instruments. You'll learn how to make the IRS your best friend. Because the IRS will do all the work for you if you fill out the right forms.
And how to bypass the banks? 'Cause
Yeah.
You're saying that they're just serving as an
Yeah,
intermediary.
exactly. Choose a new intermediary. My intermediary is the Secretary of Treasury.
So if you were actually falsely accused of some crime, maybe stealing something out of a store,
Yeah.
so.
Pay it.
Well, you could pay it, but see, there's gotta be a responsibility thing in it too, because the real guilty party is going free, because you're taking the rap for it. So how do you bring that person to justice?
So are you the judge? Is it your job to be the judge?
We have a moral obligation to the community, don't you?
You do, but if you know who's guilty, well, that's something else. You can perfect a claim against that person privately. Use Jurisdiction A. It's way more powerful. You can take all his property away from him. Like if you know what you're doing in A, nobody's going to want to mess with you. Nobody's going to want to mess with you because everyone in public, all public agents, judges, attorneys, they're all bonded. Okay? If I perfect a claim over here and attach it to their bond over here and liquidate, they're not a public agent anymore. They will not be insured or bonded anymore. And they can't serve their role if they don't have their bond.
Also, as a creditor, you're looking after everybody.
Yes, you're looking after everyone's interests.
That's the way you should look at it. Is that whether you were falsely accused or not, if you have unlimited commercial energy, wouldn't you just take care of it, settle it for your brother? What do you care if you have unlimited means? You just settle it, get rid of it.
That's true.
Yeah.
Some more questions?
Coming from abundance.
Can you talk about liability? Have you talked about liability tonight?
How do you mean? In what context?
Like, what's the definition of liability? Does liability apply in your hearings where you're in the public, or how does that affect you?
Liability.
You come in under
Admiralty law.
Oh, you mean like as limited liability versus? Okay. Okay. One of your benefits and privileges in jurisdiction B is that you operate under what's known as limited liability. Okay, all corporations, that's the reason we have corporations, operate under limited liability. Okay? Limited liability means you're not fully liable. Okay? Somebody else is going to pay your debt. Or they're going to do the work for you. Okay? Full commercial liability means I'm completely liable. I am not standing on the benefits and privileges of some third party, agency, government, corporation, or anything of the like. I'm standing in my own right, completely liable. You can only be fully liable in jurisdiction A. Jurisdiction B, everything is limited liability. That's why the judge is bonded. If he wasn't bonded, I could drag him out of the court myself and hang him under my own system of law. But he's operating under the benefit and privilege of being in limited liability. So really, I can't touch him. I can only touch his bond. Okay? Does that make sense? All right, anything else? I think maybe we'll go into title a little more. Yeah. Okay. Alrighty. Documents of title.
I have a question, just
Yeah.
going back to before the break, you talked about claims.
We had elements of commerce.
Elements of commerce.
You just talked about perfecting claims in commerce.
Mhm.
You started to say there's 3 types of claims, I think, but you never, we got.
Actually, remember, we're going into that now.
Okay.
We're starting with claims, which are titles kind of fall into claims. Okay. All right. So we talked about legal title and equitable title, right? Okay. In commerce, let's say I walk into a store, okay? Actually, maybe we should go into the prepaid account before we go into title. Let's do that. Or this kind of works together. If I go into a store and I take Federal Reserve notes out of my pocket and a can of soup from the shelf, I put the can of soup to give it to the clerk, give them my funds, what do they give me in return?
Receipt.
A receipt. Receipt is your document of title. Okay? You have title to that can of beans now, or soup, whatever it was. Okay? So you have title to the can of soup. If the can of soup is damaged and you want to take it back to get your Federal Reserve notes back, what must you have? Receipt. The title. Okay? Document of title, or a certificate of title, is issued by the legal title holder. Okay? If I hold the legal title, I issue to the party with equitable interest, I'll issue them a certificate of title, which has their name on it showing they're the beneficiary. They're the owner-operator. Okay? But they do not have legal title. Okay? It's a trust. Title itself is a trust. Okay? If you have equitable title, you're the beneficiary of the trust. If you have legal title, you're the trustee. Okay? In a trust, you can be the grantor and the trustee. You can be the grantor and the beneficiary. But you can't be the grantor, the trustee, and the beneficiary. That ain't a trust. It's a one-man corporation. Okay? Unless there are multiple beneficiaries. Then you can be the grantor, the trustee, and one of the beneficiaries. Okay? So in the case of title, if you're the beneficiary because you've been issued the certificate of title, and you're the grantor, the one who put in the commercial energy, the trustee is the one who holds legal title. Now, does anyone know how to reverse a trust? If you are the grantor and the beneficiary, and the state is the trustee, they issue you a certificate of title, right? Let's go to the example of your car, okay? You were the original grantor. You're the one who went to the state. You asked them. You said, here's my application. I want to register my car. They go, okay, we'll take legal title to your car. Here's your certificate of title showing you're the beneficiary. Okay? If I take that certificate and I change my mind, I say, you know what? I want to be the trustee. I want to have legal title. I want to be in charge of this trust. All I do is do the same thing they did to me. Accept it for value, return it to them, and now I've reversed the trust. I've certified it to them. See, initially they certified it to me because they're the legal title holder. But because I've got commercial energy, I can recertify it, give it to them, and now I've reversed the trust. Now they're the beneficial title holder, and I'm the trustee.
What am I returning?
The certificate.
You caution them not to actually go out and do that.
Yeah, no, I did it. I did earlier. Don't do anything unless you know what you're doing. Same with the title on a house. Title on a house is the grant deed, right? Grant deed is issued by who? Who certifies you a copy of the grant deed? County. County holds legal title on your property. Okay? You go down to the county and say, can I get a certified copy of that grant deed? I go, sure. $10, please. Here's your certified copy. I take that certified copy, recertify it back to them, say, yeah, I've just reversed it. I'm going to take legal title to this. Same thing with the driver's license. Driver's license is a trust. Same thing with any document of title that you get issued, the document of title gets issued to you, you reverse it by endorsing it and returning it.
Including a birth certificate.
Including the birth certificate. So the first step in being a creditor is take legal title to the body. Take legal title to the trust that was established on your behalf. Okay? That's the first thing you need to do. Nobody's a creditor unless you control the trust. You can't be a beneficiary out of control and be a creditor. Creditor has to maintain sovereignty. To maintain sovereignty, you've got to maintain control. Nobody's taken away your sovereignty. You voluntarily gave it up.
I don't quite understand how you gave, I don't understand how you gave up sovereignty because it happened when you were born and unable to write or understand.
Did your mom voluntarily fill out the application?
So my mother, as, what would you call that?
Fiduciary.
Oh, she's a fiduciary instead of a...
Trustee.
Okay. She did it for me.
Mm-hmm.
And that's still considered voluntary.
Yeah,
on my part.
until you're 21, you're considered incompetent anyways.
Okay.
So.
Sometimes after.
Yeah.
No, most people after too. But they basically, until you reach 21, when you're 21, you have the option of reversing all your trusts. Okay. You could do it before, but you'd have to, actually be responsible. 18 is bondage. 18 is, notice how you can die for your country at 18, but you can't drink because you're not responsible. 18 is not it used to be 21 was the age of responsibility. Actually, the biblical number, 21 is a biblical number, represents responsibility. 18 represents bondage.
But you can vote.
You can vote in jurisdiction B.
In bondage.
In bondage.
So as a parent, if you have a minor,
Yes.
And you've given away the title to that body, can you go back and reverse that as a parent of a minor?
Why would you?
Well, you're saying the first thing to becoming a creditor is to...
So you're making your kid into a creditor?
Yeah.
Can they be a creditor?
I don't know, can they? I mean, is it
They'd have to understand commerce to the degree of acting as a creditor.
We'll say they're 18.
Yeah, well, they could do it themselves then. You wouldn't do it for them.
Yeah, creditors take responsibility.
Yeah, you're trying to be a creditor for your kid, but that doesn't really make sense.
Well, I'm trying to emancipate them, and I thought all this, they couldn't do anything until they're 21.
They can do it when they're 18. Realistically, they can do it when they're 16, but are they taking responsibility for it? They have to take the birth certificate. They have to accept it for value. They have to return it to the Department of Treasury.
Right. Can I instruct or guide?
Yeah, you can guide them.
How young of an age can they do that?
I would say I would wait until they were of age till they understand it. Realistically, I don't want any of you doing any of this until you really understand it, because, and you're all over 21. So it's really, you would gauge it. Are they truly responsible? Are they truly taking a responsible position?
And then do they have the means by which to act as a creditor?
Yes.
Most children don't before the age of a minimum 16, maybe 18.
Yeah. They could go out, they could get, at 16, they can go get emancipated.
What does that mean?
And recognize.
What you just said right there. What did you say?
The ability to act as a creditor comes from being able to generate commercial energy. And if you don't understand the nature of commercial energy, at what age do you become available to
Speak into the
access
mic, please.
To reiterate, the ability to access commercial energy and to act responsibly isn't something that most children who are prior to the age of 16 or 18 have access to in the world, just because they are still in the education system. They're still part of the system, not a part of an aspect of the private world. They're still in the public.
Well, it depends.
But
You could keep your kid out of the public.
They can get tickets just like we can, when they're 18 or 16 or what,
Mm-hmm. And they can use their commercial energy to set them off or discharge them.
So with kids though, isn't there a way that you can get them bonded? So that, like, for example, like in a divorce situation, the state can't then control the children? I'm not a little fuzzy.
You'd have to, okay, let's look at all the documents of title that entail a divorce situation. Okay, first of all, did you get married through the state?
Yes.
Okay, so who owns the property of the marriage?
State.
The state. Who controls the marriage?
Right.
The state, right? They gave you a what? Certificate? Right? Certificate. Well, first they got you the marriage license, and then you get a marriage certificate.
Right.
Okay? Reverse the trust. Take control of that trust first.
Okay.
Now, then you've got the trust of the birth certificate. Reverse that trust. And then you've got, what other trusts do we have at play here? Let's see, we got marriage. Maybe take the marriage license as well and accept it and return
This
it.
is after two people have gotten divorced. You can still do this.
Oh, you've already gotten divorced? Well, then,
You're just accepting the divorce for...
okay, was there a court case?
This is not me.
Right, but was there a court case involved with the divorce?
No, but there's a...
How do you get dissolution in a marriage?
Just both court.
There's a judge, right? There's a judgment. Okay. You need to take that document and discharge that, whatever it was, judgment, however it came.
Okay.
And is there a conflict though between the parents?
No, it has to do with the children. That's what I'm,
Custody.
with the children.
Custody.
Is there an but are
Yeah.
both parents on the level? Like, yeah, we agree. This is how custody is going to be.
Technically, I mean, you know, on paper, but then there's always there's a lot of argument back and forth. So is it?
Okay. Well, if there's argument, then they're acting like debtors,
Right. Okay.
right?
Right.
Remember King Solomon, one of the greatest judges of all time. The two mothers bring in are fighting over a child. Okay. What does King Solomon say?
Cut it in half.
Cut it in half.
Yeah.
Now, was he really going to cut it in half?
No.
No. What was he doing?
Yeah.
Exactly. He was gauging who's the creditor, who's the debtor. A creditor is willing to risk it all. And the creditor stepped forward and said, no, don't cut it in half. Fine. If you're going to give it to her, but don't cut it in half. Proved to Solomon who the creditor was.
Last question before the break.
Yeah, the problem I see with the registration of your child on the birth certificate and leaving that way till they're, say, 18, is that they're awarded the state.
Yes.
That's what I'm asking.
This way the state can come in through social workers or whatever and take your children out of your home if they perceive a reason for that.
Yeah, unless you have a claim.
Yeah, if you file your UCC-1 and name your children
That's
on
right.
there, then I think.
But it's not the UCC1 that does the work.
Security.
That's just a notice.
Security agreements.
You need a security, a claim. If you've got a claim, nobody can touch those kids. Yeah, you get a claim, reverse the trust, take control of their trust. See, remember, you can't do it for them, but you can take control of their trust as their parent. You could say, I'm going to take their birth certificate, I'm accepting it for value and returning it. I now am the trustee. Not the kid, I am. Not the state, I am. Okay?
And if you have the highest claim, then you
Right. It's the highest.
Superior claim.
if your dog gets out, that's my dog.
Right.
If your dog gets out in the street, what's the first thing you do when you go get your dog? They say, well, you have to have a license, you have to have this, you have to have that, you have to pay pound fees, blah, 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 blah. Are they, and they have every right to do it because the dog's been, what, abandoned, right, Brandon?
Mm-hmm.
Right, Brandon? But if I walk in there with.
Well, no, not if you did license it or you haven't licensed
Dog
it.
doesn't have a license at all, it gets out.
Yeah, it's abandoned property.
I walk in with a UCC-1, says that's my property, you
Yep.
can't relieve me on my property without due process of law,
Yeah.
and you can't charge me all this stuff, that's my dog, you get your dog back.
Yeah.
Same thing with your kids.
Right.
Same thing, you can't poke my kid with that and put a bunch of poison in his body, it's my kid.
Right.
See, marriage is license, all this stuff. Once again, contractual law supersedes
Okay.
constitutional law.
Yep, we had a switch of tapes.